So now we're getting to the argument section. Okay, so we've got the three arguments. Number one is Ms. Heard has no evidence of direct liability. Ms. Heard alleges that Mr. Depp directly authorized and conspired with Mr. Waldman to make the counterclaim statements, but there is no evidence to that effect anywhere in the record. There is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. Tellingly, in response to Mr. Depp's fifth interrogatory's request that Ms. Heard state the facts supporting her contention that Mr. Depp is responsible for Mr. Waldman's conduct, Ms. Heard has offered nothing but an unfulfilled promise to provide a substantive response. Ms. Heard carries the burden of proving her allegation that Mr. Depp intentionally directed Mr. Waldman's conduct. And that's kind of the kicker here, right? Because she's the one with the burden to prove. If she doesn't have evidence, she loses. That's just how the burden of proof works. If, on the other hand, Johnny Depp had the burden to prove any of these claims, it would be on him to provide it. It would be a serious bit of pressure on him to find that evidence, produce that evidence, square that all away. But in this case, with regard to the counterclaims, because Amber's the one with the burden of proof, if she doesn't have it, she loses. So in order to find Johnny Depp liable for any of these statements, remember, he didn't actually make any of these statements. All of them were made by Adam Waldman. So she has to not only show that Johnny Depp has some sort of a connection to him that could possibly make him somehow responsible for someone else's statement. Because remember, as we go through life, generally speaking, we are not responsible for what someone else does unless there is a very specific reason to put that responsibility on us. So usually we're talking about vicarious liability. Think of, for example, an employer that is responsible for one of its employees, maybe a supervisor at work, for example. That's a good example of vicarious liability often. Or, let's say, a truck driver gets into an accident. That could be liability that the truck driver would have. That could be vicariously applied to his employer because he's in the process of doing his duties as an employee. Those duties benefit his employer. There's a whole sort of list of boxes to check in order to meet a standard for vicarious liability. You can also have liability if there's some sort of a conspiracy between them. So this whole first argument is saying there's no conspiracy. And in fact, and they don't actually need to show that there's no conspiracy. All they need to do is show that Amber Heard has no evidence that there is a conspiracy between them. So if she doesn't have any kind of evidence for that, then she can't claim conspiracy. She can. Now we'll get to number 2 where we are talking about vicarious liability. But so far, it's saying that there's nothing. She hasn't responded to the discovery in any substantive material way that would allow for any defendant to those claims to be able to kind of work with, So because she hasn't provided any kind of responses, which, by the way, she has a responsibility to do. Anytime any party gets discovery requests, they are supposed to provide good substantive responses to the best of their ability. You can't just shirk those. And my guess is the only reason why why Johnny Depp's attorneys kind of allowed that response to sit is because the evidence that would be forthcoming in that kind of a response would go to these counterclaims, which they don't have a burden to prove. The burden is on Amber Heard. So that is number 1. Argument number 2. Ms. Heard cannot prove actual malice by Mr. Waldman. To the extent Ms. Heard attempts to argue, contrary to her counterclaim, that she is merely seeking to hold Mr. Depp liable under a vicarious liability theory, Ms. Heard's arguments fare no better. To state the obvious, vicarious liability is liability for the tort of another person. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman committed all elements of defamation. And this is true. This is very true. First, you have to, it's like when you have liability for that you are applying to one person because of something that somebody else said, you have to show first off that the thing that the other person said was actual defamation, and number two, that you can extend that liability to that other person that you are actually suing. So this is pretty spot on. The elements of defamation are: 1, publication of; 2, an actionable statement; with 3, the requisite intent. I don't like that breakdown of elements because you still have to define actionable statement. What does an actionable statement mean? Basically, this is just how Virginia breaks it down, but it basically means the same thing across most states, that somebody lied about the plaintiff to another person or group of people, and the result of that lie is that there was some serious reputational harm, and that there was a certain level of intent. Okay. Anyway, back to the actual motion for summary judgment. A public figure must prove by clear and convincing evidence that a defamatory statement was made with actual malice, i.e., knowledge that it was false, or with reckless disregard or of whether it was false or not. Reckless disregard, quote, is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. And this is, of course, citing to U.S. Supreme Court case law. The Virginia Supreme Court has confirmed that summary judgment is appropriately granted against a plaintiff that fails to present evidence from which a jury could find actual malice by clear and convincing evidence. Here, Ms. Heard is a public figure and, as such, must establish that Mr. Waldman uttered a defamatory statement about her with actual malice. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false, nor is there any evidence in the record that Mr. Waldman subjectively entertained serious doubts about the falsity of the counterclaim statements. Ms. Heard's factually empty response to Mr. Depp's 5th interrogatories is damning. She had an opportunity to explain how Mr. Depp can be held legally responsible, which requires, as a threshold matter, establishing that Mr. Waldman committed the tort, including acting with actual malice. She cannot meet her burden. Yeah, no, I mean, this, if that's the case, like I said, I wish that the separate statement were, you know, although I guess it really wouldn't matter here. If this is the only possible evidence is, they requested her response to the 5th interrogatory, and she just didn't really respond with any kind of real substance. I think, yeah, I mean, if there's no evidence, there's no evidence, despite them requesting it. It'll be interesting to see what their response is to this, because I don't know if there has been any kind of request to depose Adam Waldman, but that's so tricky anyway. Like, trying to depose the opposing party's attorney or former attorney, because I know that right now there's a deposition request by Johnny Depp's legal team to depose Amber Heard's former attorney. And I know that there's been a motion for a protective order that was filed for that. Adam Waldman was deposed? I'm seeing that in the chat. On February 15th, he was deposed. Interesting. So that's even more interesting. Although, okay, so in Virginia's funny because apparently, I was reading. So I'm not licensed in Virginia. I'm licensed in California and DC. But I was, to prep for this, I was reading that in Virginia, a motion for summary judgment cannot even use a deposition. It can't use deposition testimony for either to support or to um, fight against a motion for summary judgment, which is just weird to me because I'm so used to California where you can use literally any and all of the evidence that has been sent around between the parties. So it's interesting. It's interesting to me that that they can't use it here unless they have somehow agreed to it, which my guess is that they haven't, unless somebody knows otherwise. But so even though he apparently has been deposed, number one, I'm very curious as to how that went because they typically cannot get into um the there's a lot that they usually can't get into because of the fact that the um the relationship between the two of them, the communications between them are usually privileged because of the fact that we're talking about an attorney and a client. So anyhow, weird. I'm very curious to know how that actually went down. But I would also like to know if there really is any other evidence, because if this is it, the response to the fifth interrogatory, I don't know how Amber Heard's attorneys are going to respond to this motion. Because it's true. In order for her to show that Johnny Depp was somehow vicariously liable, she would need to show that Adam Waldman acted with actual malice, which is a very high burden. Anyhow, okay. Argument number 3. In context, the counterclaim statements are protected opinion. Finally, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. Indeed, a statement cannot be defamatory if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. Pure expressions of opinion cannot form the basis of an action for defamation. And then it cites to some Virginia case law, noting that where all sides of the issue, as well as the rationale for the speaker's view, were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, and finding an accusation of deceit to be opinion. So basically, where you have the reasons for this person, why they're saying what they're saying, you're showing that this person is somebody's lawyer. Of course, like that's enough information right there to be able to take anything that they say with a grain of salt, because of course they're going to be supporting their client because they kind of have to as their lawyer. As is explicitly reflected in statements F, G, and H, the counterclaim statements were each made in the context of highly public and contentious litigation with conflicting testimony from both sides. Each article lays out two diametrically opposing characterizations of the facts by opposing attorneys. Each article presents Mr. Waldman's assessment of particular items of evidence or developments and the opposing side's very different assessment. Each article is explicit that the facts are very much in dispute. Indeed, the main thrust of each article is to describe the clash of completely different views between the Depp and Heard camps. Oh, hey, Kurt. How's it going? Uncivil Law. Good to see you in the chat. In context, any reporter or reasonable reader would understand and expect a lawyer associated with Mr. Depp to challenge Ms. Heard's version of the inherently murky events of the party's marriage, just as Ms. Heard's lawyers challenged Mr. Depp. I mean, yeah, that's my reading of those statements. That context necessarily negates any suggestion that the statements are properly understood as subjective statements of fact that could be deemed defamatory. And then it cites to the case Chaves, another Virginia case. The most unsophisticated recipient of such a claim made by one competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias. That seems to be pretty applicable in this case, and then they cite to Partington v. Bugliosi. And now this one is a Ninth Circuit opinion, so it's not Virginia, but it's supportive anyway, and the court can use it if they want. It says if a statement is made in a forum in which a reader would be likely to recognize that the critiques represent the highly subjective opinions of the author and relates to inherently ambiguous subject matter about which reasonable minds could draw different conclusions. Hey, it's like they've been watching Hoglaw's channel. Reasonable minds can differ. Then the general context in which the statements were made negates the impression that they imply a false assertion of fact. And it seems like, if the quotations were in the they're in this article immediately following or immediately before statements by Amber Heard's attorney or, counsel for the son. It seems like, I don't know, this is it fits in this case law precisely. Mr. Waldman's opinions are not presented as a definitive version of events or as statements of a percipient witness, but as mere advocacy, one side of a fiercely contested story as characterized by a lawyer, where it is clear from context and the content of the statements that the facts are contested. I kind of agree. And then it cites to Potomac Valve and Fitting Inc., the Crawford Fitting Company. This is Fourth Circuit, so it's federal court, but that is where Virginia is in the Fourth Circuit. It says that the case said that the summary judgment is appropriate where the statement in question readily appears to be nothing more than the author's personal inference and where a reasonable reader would recognize the author as biased and would not expect a dispassionate and impartial assessment. Mr. Waldman is never described as a fact witness with personal knowledge, but merely a lawyer, a partisan hired gun, expressing his opinion and evaluation about a he said, she said dispute. More case law from the Fourth Circuit saying no liability where there was no claim to firsthand knowledge of facts, and the context and tenor of the article thus suggests that it reflects the writer's subjective and speculative supposition. Yeah, I mean, this is about correct. I'm going to skip just a little bit ahead. Ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view and interpretation, a theory, a conjecture, or surmise about events he never claims to have witnessed. No reasonable reader would believe otherwise, especially as Mr. Waldman's statements are directly contradicted by Ms. Heard's lawyers in the same the same articles. Moreover, the recipients of Mr. Waldman's statements, whether reporters or readers, were necessarily informed of the existence of factual disputes, the reporters having written articles about describing the disputes, and the readers having read them, which negates defamation. The statements are no more than vivid expressions of opinion from which no liability for defamation can arise. For the foregoing reasons, the court should grant the motion. And then that's the end of it.